22 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the...
This courtroom hearing starts off routine. But within minutes, the judge notices something that could completely change the legal outcome of the case. A woman named Miss Lockhart is facing charges connected to attempted arson. But right away, the court begins questioning whether the paperwork even lists the correct offense. What starts as a standard plea hearing quickly turns into a careful examination of legal details, potential sentencing ranges, and the defendant's personal situation. But that's not all. As the hearing unfolds, shocking details emerge. Homelessness allegations, a fire started in a field, and a revelation that the defendant is pregnant while facing criminal charges. The judge now has to decide whether Miss Lockhart deserves a second chance through community supervision, or something far more serious. The question is this a case of criminal intent, or someone struggling with deeper personal issues?
Okay, why do you guys have this filled out as a state jail? All right, so you all need to redo this piece of paperwork. And I would suggest that you use the felony paperwork. That way you can write it in, because otherwise I don't have knowledge that she knows that it's a class A, because that's not how it's listed. Oh, okay, you are correct. Look at this. Corrections are happening. I appreciate it. I hate to correct you. That's no. Here's the thing. I always tell people, make sure that if I'm saying something that's incorrect, to let me know. Okay. All right. So this is what I'm going to need you all to do, though.
Incredibly important.
I need her to initial it, so I know that she knows, because all of this is state jail felony paperwork. That's why I
initially,
state jail.
The paperwork suggested a state jail felony, which in Texas carries a potential sentence of 180 days to 2 years in a state jail facility and up to a $10,000 fine. But the defense attorney catches something crucial.
Because
the
all
offense is
this
actually
paperwork
attempted
is state
arson
jail
causing
felony
damage,
paperwork,
which reduces it to a Class A misdemeanor. That difference is massive. Instead of facing time in a state jail facility, the defendant now faces up to 1 year in county jail and a fine of up to $4,000. Moments like this show how critical it is for attorneys and judges to carefully review legal documents in
carefully
court.
read through the
One
paperwork. Just
mistake
give me a
on
moment
paperwork could
to
mean
make sure
years
that
of
everything
someone's life
is
on
the
the
way it
line.
should be.
So here's a question for you watching.
As arson as a
think this was
class A
simply a
misdemeanor,
paperwork
the
oversight,
range of
or
punishment
could it
for
have
that
seriously
offense is up to
impacted the fairness of the
$4,000
case?
fine and up to a year in a Bear County jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
It's to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Sure.
Anything you wish to say on behalf of your client? All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 North.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out, why were you homeless and why would your father let you live with him now?
Judge, if I could just have a second.
You need to be honest with me, because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to Bear County Jail. They're going to do a PSI report, and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions, and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items, and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
Why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
Now, the hearing
pregnant.
shifts from
Okay.
legal
I just wanted
technicalities
to
to
hear it.
something much more
And how far
personal.
along?
The judge starts
Like
digging into the
21,
circumstances
22
behind the
weeks,
fire,
yeah.
and the police report paints a troubling
Judge,
picture. According to
I didn't mean to be
investigators,
presumptuous, but I
Miss
have been in
Lockhart
this
may have
court once or
started the
twice
fire
before.
while
I
trying
did
to
tell
dry a
her she was gonna
blanket,
be taking a
suggesting
parenting
she might have
class,
been
which
living
was
outdoors at the
theoretically
time.
outside.
The
But
judge presses
changed
for
to mention
answers
that
about
your
why she
parenting
appeared to be
class going
homeless,
forward.
even though
Is
she
that
now
something
says she
you
can
want?
live on property owned
All
by
right,
her
and
father.
is she
And then
on
another
medications
surprising
at the
detail
jail?
comes
Yes,
out.
Judge. She
Miss
was not on
Lockhart is
medication at
pregnant,
the time. Now
roughly
she is on
21 to 22
medication.
weeks
She's
along. Suddenly,
frankly
the
alive.
case becomes about
She's
far more
definitely
than just
competent at this
property
point in
damage.
time.
The court
At the
now has
time
to
that she
consider
was
mental
not
health treatment,
being
parenting
rational,
classes,
but at this
and
time,
stability for
she is
someone who
going to be
may soon be
successful going
responsible
forward.
for child.
There is the part about the
Situations
mental
like this raise a
MIC
difficult
caseload and
question.
her being interviewed
Should the
for that.
justice system
I
focus
believe
more
that
on
would be
punishment
necessary.
or
And she
rehabilitation
understands
when
that being
personal
med
struggles are
compliant is going to
involved?
be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked the evaluations be done when she's out of custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, yes,
All
Your
right,
Honor.
because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time,
Mhm.
we've conferred with the DA, and this was the attempt. She's got quite a bit of time, so this is our agreement that we reached.
All right.
She was approved. I know that she's being evaluated for mental at the MIC caseload,
Mhm.
being that it's a misdemeanor, but mental health court, I don't think that was approached because it wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea,
Yes.
then the court will consider that.
That's what I was thinking ahead, Judge. That's why my brain was going like, I don't know if it looked like I was rolling my eyes. Does that mean that she wants? Yes. Okay.
All
I'll
right,
explain that.
so,
Thank
Rashawn,
you.
if you can, you're welcome. Rashawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they're willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day.
Thank you.
And I'll explain in a second what she's doing and it's really helping her out.
All right, and they'll put you back in the box so probation can speak.
In the end, the judge decides not to send Miss Lockhart straight to jail. Instead, the court orders 2 years of deferred adjudication, which is a form of probation where conviction can be avoided if a defendant successfully completes all requirements. But that second chance comes with strict conditions. She must complete mental health evaluations, parenting classes, community service, drug testing, and regular probation check-ins, along with proof of employment or SSI benefits. The judge also ordered referrals to treatment programs and even potential entry into mental health court, which could allow the case to eventually be dismissed if she completes the program successfully. This ruling shows a court balancing accountability with rehabilitation, especially considering the defendant's mental health and pregnancy. But what do you think about the outcome? Was this the right call by the judge, or should the court have taken a tougher stance on the attempted arson charge? If you found this courtroom case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.